This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. There's recently been a remarkable ruling out of California over the Assembly Bill 5, which is the state statute that expands, well, it's called the Dynamex case, but it's the independent contractor versus employer distinction. Normally, independent contractors can just be paid in cash or check, no need to take out taxes, no need to worry about all that. They do that. When you go to buy something from your local Best Buy or Costco or whatever, you don't have to think about, does Costco pay their taxes? Does Best Buy pay their taxes? Well, on the in-between, when you go and pay your landscaper who is not formed as a business corporation, but is rather formed as an individual person, do you have to pay them as a contractor or an employee? And then if they are formed as a company, do you have to do some sort of analysis to figure out whether they are a contractor or employee of yours? And it gets really complicated. So this was supposed to help by setting sort of the thresholds for where these things are. And we're going to look at exactly where these lines are in the case. But this here, California Assembly Bill 5, is what we're talking about. In response to the passage of AB 5, there were lots of freelancers who claimed they were going to completely lose their jobs, and there's lots of legitimate and reasonable concern there. Uber and Lyft, for their part, they attempted to change the law themselves and have made their own, I think it's Proposition 22, but ultimately if they fail, their drivers will be considered employees and will be entitled to employment benefits, to unemployment compensation, insurance or whatever, to health care benefits, whatever is required by law. They'll be under the control and purview of Uber and Lyft, even more so the doctrine of respondeat superior, that your boss is liable for your negligence or your acts in the course of your job. All of that will sort of reverse course and become Uber and Lyft's problems. I'll stop characterizing it, and what we'll do is we'll go straight to the highlighted sections of this 34-page complaint in the Superior Court of the State of California. This is the judge's order on the People's Motion, so that's the government of California, the People's Motion for a preliminary injunction and related motions. On May 5th, 2020, the Attorney General of California, joined by the city attorneys of Los Angeles, San Diego, and San Francisco, filed this action on behalf of the people of the state of California seeking injunctive relief, restitution, and penalties against defendants Uber Technologies and Lyft. The complaint asserts that Uber and Lyft have misclassified their ride-hailing drivers as independent contractors rather than employees in violation of Assembly Bill No. 5, which took effect January 1st, 2020. That statute is intended to ensure that all workers who meet its criteria receive the basic rights and protections guaranteed to employees under California law. The People's Complaint states causes of actions for violations of AB 5 and the unfair competition law, which we've seen several times before is California Business and Professions Code 17,200. On June 25th, the people moved for a preliminary injunction enjoining defendants from classifying their drivers as independent contractors and from violating any provisions of the labor code, etc. This just means that it's going to happen now for them instead of after some appeal or something like that. Defendants oppose the motion. Defendants' motions have in common an attempt to delay or avoid a determination whether, as the people allege, they are engaged in ongoing and widespread violations of AB 5, a state law that went into effect more than 7 months ago. Defendants are not entitled to an indefinite postponement of their day of reckoning. Their threshold motions are groundless. Defendants seek to stay the litigation until the Ninth Circuit rules on Uber's pending constitutional challenge to AB 5, and until the November 2020 election when the voters will consider Proposition 22, an initiative sponsored by Uber and Lyft that would exempt them from the requirements of AB 5. None of defendants' pleas for further delay is persuasive. That Uber and Lyft are attempting to persuade the voters to change the law, an effort that may or may not succeed, is no reason for this court to refrain from deciding the issues currently before it. Finally, none of the pending lawsuits and arbitrations can displace the legislature's express statutory grant of authority to the Attorney General and city attorneys to seek injunctive relief to prevent the continued misclassification of employees as independent contractors, and none is likely in the near term to resolve the issues presented here in a broadly applicable ruling. In the ordinary case, in deciding whether to issue a preliminary injunction, a court must weigh two interrelated factors. One, the likelihood that the prevailing party will ultimately prevail on the merits, and two, the relative interim harm to the parties from issuance or non-issuance of the injunction. The people have amply demonstrated a reasonable probability of prevailing on their claim that defendants are misclassifying their drivers. Whether defendants' drivers should be classified as employees or independent contractors is governed by the so-called ABC test, established by the Supreme Court's unanimous Dynamex decision, which AB 5 codified. Under that test, a person providing labor or service for remuneration shall be considered an employee rather than an independent contractor unless the hiring entity demonstrates that three conditions are satisfied. A, the person is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. B, the person performs work that is outside the usual course of the hiring entity's business. And C, the person is customarily engaged in an independently established trade, occupation, or business of the same nature that is involved with the work performed. Because defendants cannot possibly satisfy the B prong of that test, the likelihood that the people will prevail on their claim that defendants have misclassified their drivers is overwhelming. There is no need to address the other two prongs of the test. It's this simple. Defendants' drivers do not perform work that is outside the usual course of their business. Defendants' insistence that their businesses are multi-sided platforms, rather than transportation companies, is flatly inconsistent with the statutory provisions that govern their businesses as transportation network companies, which are defined as companies that engage in the transportation of persons by motor vehicle for compensation. It also flies in the face of economic reality and common sense. And it is irreconcilable with the Supreme Court's directive in the Dynamex case that California's employee classification standard should be interpreted and applied broadly to include all persons who can reasonably be viewed as working in the hiring entity's business. To state the obvious, drivers are central, not tangential, to Uber and Lyft's entire ride-hailing business. Turning to the equities, the people have shown that substantial public harm will result if the court declines to issue an injunction. The controlling legal standard creates a presumption of harm, whereas here, a party is violating a statute that was enacted to protect the public. In the specific context involved here, both the legislature and our Supreme Court have found that the misclassification of workers as independent contractors deprives them of the panoply of basic rights and protections to which employees are entitled under California law, including minimum wage, workers' compensation, employment insurance, paid sick leave, and paid family leave. They have also found that depriving employees of those rights has ripple effects on law-abiding competing businesses and on the public generally. On the other side of the balance, defendants do not show that they will suffer grave or irreparable harm from the issuance of an injunction. While they undoubtedly will incur costs in order to restructure their businesses, the costs are only those required in order for them to bring their businesses into compliance with California law. Moreover, these are costs that defendants should have begun incurring more than 2 years ago, when the Supreme Court handed down its unanimous Dynamex decision. As another court observed, rather than comply with the clear legal obligations, companies like Uber and Lyft are thumbing their noses at the California legislature, not to mention the public officials who have primary responsibility for enforcing AB 5. It is high time that they face up to their responsibilities to their workers and to the public. And then the court goes into defendants' various attempts to delay. Their motions to stay are denied. Their objections and motion to strike are denied. They tried to compel arbitration. That's denied. And then the court goes a little bit into the Dynamex case, so in case you were wondering. Dynamex involved a complaint by 2 delivery drivers suing on their own behalf and on behalf of a class of similarly situated drivers against Dynamex, a nationwide package and document delivery company, alleging that it had misclassified its delivery drivers as independent contractors rather than employees. After the trial court certified a class action, finding that the common issues relating to the proper classification of the drivers as employees or as independent contractors predominated over potential individual issues, Dynamex unsuccessfully sought to decertify the class and then filed a writ proceeding in the Court of Appeals regarding the proper definitions of employee and employer for purposes of the wage orders. The Supreme Court granted review to decide that issue. After an extensive review of California and out-of-state judicial decisions regarding the employee or independent contractor distinction, the court held that the wage orders suffer or permit to work definition must be interpreted broadly to treat as employees and thereby provide the wage orders protection to all workers who would ordinarily be viewed as working in the hiring business. In particular, the court held that in determining whether a worker is properly considered the type of independent contractor to whom the wage order does apply, it is appropriate to look to a standard, commonly referred to as the ABC test, that is utilized in other jurisdictions in a variety of contexts to distinguish employees from independent contractors. On the facts disclosed by the record, the court went on to hold the trial court's class certification order was correct as a matter of law under this ABC test, and the Court of Appeals judgment therefore was affirmed. Defendants contend first that AB 5 does not apply to them at all. That contention is impossible to square with defendants' own litigation positions and lacks any merit. The court is under no illusion that implementation of its injunction will be costless or easy. There can be no question that in order for defendants to comply with AB 5, they will have to change the nature of their business practices in significant ways, such as by hiring human resources staff to hire and manage their driver workforces. If the ABC test is found to require the reclassification of their drivers, they would also suffer significant harms associated with restructuring their business. But that argument at its root is fundamentally one about the financial costs of compliance. Defendants' contention that the costs of complying with existing law are properly considered irreparable is questionable. But even if they are, those are costs that defendants reasonably should have anticipated bearing at least since April 2018 when Dynamex was decided, and certainly since September 2019 when AB 5 was enacted and signed into law. As one district court has observed, AB 5 contains no exception for wealthy corporations that disagree with the legislature's policy judgment and would rather not spend money to effectuate that judgment. The court does not take lightly defendants showing that a preliminary injunction may also have an adverse effect on some of their drivers, many of whom desire the flexibility to continue working as they have in the past, and many who have commitments that make it difficult, if not impossible, for them to become full-time or part-time employees. As defendants argued at the hearing, those concerns are magnified by the sweeping scope of the injunction sought by the people, and by the court's uncertainty as to how precisely defendants will go about complying with it. But if the injunction the people seek will have far-reaching effects, they have only been exacerbated by defendants' prolonged and brazen refusal to comply with California law. Defendants may not evade legislative mandates merely because their businesses are so large that they affect the lives of many thousands of people. Moreover, concerns about the effects of the court's injunction on drivers are substantially mitigated by at least two factors. First, as defendants themselves emphasized, the vast majority of their drivers work on a casual or sporadic basis, and for only a small number of hours per week, and thus the effects on those drivers of a reorganization of defendants' businesses are likely to be correspondingly minor. Second, the ongoing effects of the coronavirus pandemic have drastically reduced the demand for drivers' services, and even those drivers who are able to find work may elect not to do so to avoid exposing themselves. Now, when defendants' ridership is at an all-time low, may be the best time, or the least worst time, for defendants to change their business practices to conform to California law without causing widespread adverse effects on their drivers. In short, as the Federal District Court concluded in the Olson case, considering the potential impact to the state's ability to ensure proper calculation of low-income workers' wages and benefits, protect compliant businesses from unfair competition, and collect tax revenue from employers to administer public benefit programs, the state's interest in applying AB 5 to defendants and potentially hundreds of thousands of California workers outweighs defendants' fear of being made to abide by the law. Although defendants have shown some measure of likelihood of irreparable harm, the balance of equities and the public interest weighs in favor of permitting the state to enforce its legislation. For these reasons, defendants' motion to stay this action are denied. Lyft's objections are overruled, and its motion to strike the people's complaint is denied. And the court defers any ruling on defendant's motions to compel arbitration to a later hearing date to be set upon further order of this court. The people's motion for a preliminary injunction is granted as follows. During the pendency of this action, defendants Uber and Lyft are hereby enjoined and restrained from classifying their drivers as independent contractors. They are further enjoined and restrained from violating any provisions of the Labor Code, Unemployment Insurance Code, and the wage orders of the Industrial Welfare Commission. Drivers refers to the following two categories of individuals. First category, all individuals who drive for Uber as ride-hailing drivers in the state of California, etc. Second category, all individuals who drive for Lyft under the same conditions. The injunction is stayed for a period of 10 days. It shall remain in effect through and including the trial of this matter or upon further order of this court. That's Ethan P. Schulman, Judge of the Superior Court of California. And so that's really remarkable. This only applies to California, but this could have wide-ranging implications for the rest of the country if authorities in other parts of the country decide that Uber and Lyft are hiring people as employees, but paying them and treating them as independent contractors. So I really like the unfair competition argument in there, that by paying them in this independent contractor structure, they save money and therefore are able to compete unfairly against businesses who do pay and structure their employees properly. So I kind of agree with California on this one. Even though I would just love to have cheap Uber rides, I do also care about the people who drive and work. They should be properly compensated. They should have the insurance that they need, etc. This sort of brings up an area of politics, but it should be discussed. These contractors lack health insurance from the company because they were classified as contractors. Once they're classified as employees, certain regulations will apply and they'll have to be given health insurance. Shouldn't we just disconnect the health insurance from the employment and just give everybody health insurance, whatever the requirements are, make it fair so that poor people can have it and wealthy people can pay for it? I'm happy to pay for my health insurance. I just don't want it to be so connected to my job that I can't leave my job without losing my health insurance. If I could leave my job without losing my health insurance, which I realize is not my situation right now, it was my situation 10 years ago, but if I could leave my job without losing my health insurance, that would foster competition. People would stay with the companies that treated them best, not stay with a company just because they need their health insurance. Anyway, let me know what you think in the comments below. All right, that's our show, everyone. Thanks for joining me. Let me know what you think in the comments below. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, Floatplane, and Twitch. We are community supported, and we only exist because of your monthly support on patreon.com/ljfrench and sponsors.com/law. Thank you in August to our $50 plus supporters: Nicely Done Defense, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Benjamin Hitov, Steven, Blackleaf, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, Engi, Brandyn, Abel, Torpedan, and Creative Corruptions. And thank you to the $5 plus supporters who... And thank you to the $5 plus supporters who will be in the description of the videos. I love you all. I will see you in the videos that drop. Bye.